All right, you may proceed.
I, I don't have any further questions, Your Honor.
All right, ma'am, be back in just a moment. Call your next witness, please.
Uh, State calls Larry Noel.
All right, I'm sorry,
No, I
ma'am.
was.
Did
Oh,
he tell you
sorry.
what type of drugs he was on or he was using at that on that date?
He said he's been doing coke.
All right. And did he ever tell you that before or since?
I mean, he's told me that he's done it in the past, way before I met him. He said he used to do it.
Okay.
Today's custody hearing opens with child support mostly settled, but visitation explodes immediately. A 4-year-old triggers Texas standard possession rules, and the judge wants facts, not feelings. Mom and dad disagree sharply on access, safety, and control. Stay sharp. Subscribe, like, and share for courtroom breakdowns as tensions rise fast now.
I believe that we have an agreement on the child support numbers, the retroactive total. But I believe that we have agreement on geographic restriction, but we do not have agreement on the visitation, Your Honor.
All right, she's 4. Let me see what these circumstances are. Here's the deal, folks. Under Texas law, the non-custodial party is entitled to a standard possession order. Standard possession orders come into full force effect after the 3rd birthday. This child's over the age of 3. So what I need to know is the circumstances as far as visitation and access to the child the father has had, and see whether or not the court should go ahead and start standard visitation day 1 in accordance with the Texas Family Code. And now, folks, I just laid out a lot of legal mumbo jumbo, but the bottom line is that's the standard I'm gonna have to look at. So again, I'll let the state tell me what y'all had in agreement and see whether or not that the court can go along with any request on the visitation based on what both parties are trying to accomplish. So at this time, I ask you both to raise your right hands and let me get you under oath. All right, do you both solemnly swear or affirm your testimony you're going to give here today is the truth, the whole truth, and nothing but the truth to help you?
I do.
I do.
All right, you're both officially under oath. You can put your hands down. I'll let the state call you both as witnesses. And at the end of the hearing, if there's anything either you wish to tell the court, so long as it's relevant, you can tell the court that information. But the court gets to determine what's relevant because pro se litigants like to go afield sometimes. And right now, the only thing I'm interested in are the 4 corners of your pleadings. And that means, conservatorship, child support, visitation. So let's see what we got. You may proceed with your first witness, Ms. Metzer. Thank you.
Yes, Your Honor. I'll call Tahisha Bryant. Ms. Bryant, will you state your name?
Tahisha and Bryant.
Okay. So we have discussed the numbers before, and we decided that the child support should be calculated at $621 per month starting October the 1st, 2025, correct?
Correct.
And the medical support should be $104 per month starting October 1st, 2025, correct?
Correct.
And dental support should be $4 per month starting October 1st, 2025, correct?
Correct. Yes.
And we calculated the retroactive total to be $12,492 total, right?
Correct.
And the repayment was $112 per month starting October the 1st, 2025.
Correct.
Correct? Okay. And do you have access to private medical insurance for Azaria?
She gets her medical insurance through me, which is through Scott and White, and it's Cigna.
And that's how we calculated that $108 per month amount, right?
Correct.
And that's just for her, not including you, right? That's how we calculated it.
Yes, the amount that was calculated is just for her.
And then for the dental support, we calculated that by prorating it because 4 people were on your dental insurance, or 5 people were on your dental insurance, right?
Correct.
And so that $4 is just for her, right?
It's just for her.
Okay. And we calculated the retroactive total because you gave him credit for some Cash App payments. Is that correct?
Correct.
Now, as far as the retroactive total, we wanted it to start on your daughter's 2nd birthday. Can you explain why?
For the first 2 years of her life, he was more involved and he was doing more. After that time period, he wasn't. It was harder to get him to provide for her for the things that he needed. It was always, I can't right now, I don't have it right now, or if him and I were not talking at that time, then he would absolutely wouldn't do anything for her because he felt that because he couldn't see her, then she wasn't his responsibility.
Okay. And I'm sorry to switch gears here, but you're in agreement with the geographic restriction to Bell County and contiguous counties, correct?
Correct.
And you do want to communicate with Mr. Noel via app close.
Yes.
Okay, why is that?
Because when I don't answer his
Ma'am,
phone
ma'am, ma'am,
calls
here's the deal,
or
ma'am, here's the deal. I want to do that, period, okay? The last litany of information you just went through got you there before you even had to answer that question this time. So I want everybody on app close, because app close is a concise documentation device. I hate trying to get information out of text messages, and that app will, if I need a text, it'll print it out like a book. All right. So okay. And I know it's correct, and it's not been spoofed or created by some type of AI. So yes, ma'am, we're going to use app close going forward. So there's no explanations necessary. We proceed
Yes,
to
Your
okay.
next
Yes, Your Honor.
Dispensers. Thank you.
Yes, Your Honor. Okay. Now, specifically, how do you see visitation going between Azaria and Mr.
Okay, here's the
Noel?
deal. Give me the history of visitation, and we'll take it from there. Okay.
Yes, Your Honor. What is the history of your visitation, Miss Bryant?
The history of visitation is I've always been present when my daughter has been there. Either I've come over and we stayed for a couple of hours, or in the past when we worked together, I would stay the night. That's how visitation has always been. I do not feel comfortable with her being there over the weekend with him because of the people that.
Okay, ma'am, stop. You answer the question. Don't go to the next level.
Okay, I'm sorry.
And what I need to know, when's the last time the father had any kind of access to the child?
About 2 weeks ago.
And what was that visitation like?
It was fine.
I mean, what was it? How long? Where was it? What was the circumstances?
It was at my house, and it was for about 45 minutes.
All right, any time before that?
Probably a week or 2 weeks before then. Same visit at my house for about 45 minutes.
Okay. So, and how long y'all been doing that at your house, at your residence for 45 minutes to an hour for us, anytime, been at your house, ma'am? How long have y'all been doing that? And give me your best guesstimate on how many visitations he's had this year. Thank you.
Maybe about 6 visits this year.
All right, thank you. You may proceed. You may expand on that question if you need to, Ms. Baxter. Thank you.
Okay. Do you believe that if he has your address or phone number, that you or Azaria would be in danger, physical danger?
No.
So, do you want a supervised visit between Mr. Noel and Azaria?
Yes.
All right, ma'am, why? Why do you think there needs to be supervised visitation going forward?
The
Here's the deal, ma'am. Here's the deal, ma'am. You can testify to anything that you are an eyewitness to or seen, and the more recent, the better. And but you cannot testify to anything a third party told you. But you can testify to anything you've seen and anything that the father has told you. So keep that in mind in your answer, ma'am. Thank you.
Okay. I can testify to the type of people that he's had at his house. The only people, I'm sorry.
And what type of people are those, ma'am? Again, unless you saw them doing something, again, how do you know that the people you've seen at his residence will somehow be harmful to your child?
I have not seen anyone in the act of doing something wrong or illegal.
Okay.
And you said not to say anything of a third party or anything of what he said.
No,
But
you can testify to anything that the father has told you, but you cannot testify to anything else someone else has told you about, especially another third party. Technically,
okay,
you can't even testify to anything that a third party told you about the father. So,
well, from the father's mouth, he have said that some of his friends are have gone to jail. He said of some activities that go on in his house.
and what has he told
And
you? What has he actually told you about any activities at his residence, ma'am?
he has a pool room, and they go in there and they smoke and they drink and they do drugs in that room.
Okay, ma'am. He told you he's done drugs.
Yes.
Okay, and when did he tell you that? And in what circumstances?
I went over to his house probably about a month ago, and he wasn't acting himself. And I asked him, I said, normally you are a little bit all over the place, but today is a little much. Like, what's going on with you? And he just kept laughing, and he was like, oh, I've just been doing drugs. And I told him, I said, don't play around. That's not funny.
Okay.
And at the moment, I wasn't sure if I should take it seriously or not. But his personality, normally he is a very hyper person.
Here's the deal, ma'am. You can't explain why you did what you did or heard what you heard. You can only testify to what he actually said. Unless you have a PhD in psychology or some type of law enforcement expert on drug use, then ma'am, you can't testify to something like that. Thank you.
Okay.
All right, state may proceed with the next question.
At this moment, the judge clamps down on speculation. He allows only first-hand statements, not rumors, and forces Mom to repeat exactly what Dad allegedly said about drugs. That legal filter matters. Credibility survives only clean testimony. Would you risk your case by guessing instead of proving your child's future?
All right, I'm sorry, ma'am. Did he tell you what type of drugs he was on or he was using at on that date?
He said he's been doing coke.
All right, and did he ever tell you that before or since?
I mean, he's told me that he's done it in the past, way before I met him. He said he used to do it.
Okay. All right, you may proceed.
I don't have any further questions, Your Honor.
All right, ma'am, be back in just a moment. Call your next witness, please.
State calls Larry Noel. Larry, can you state your name? Mr. Noel, you've got to unmute yourself.
I apologize. Larry Noel II.
I'm sorry, what was that you said?
Larry Noel II.
Oh, okay, the second. Okay. Did you apply for services with the Office of the Attorney General?
Yes, I applied. Yes, ma'am.
And you sent me a check stub that says that you make $21.84 per hour and work 40 hours per week, correct?
Yes, ma'am. Yes, ma'am. At
And
Wilson Art.
And you've
sorry.
been at this job for the past 4 years, correct?
Yes, ma'am.
And those numbers that I said you're in agreement with, right?
Yes, ma'am. I have no choice. Yes, ma'am.
You do. You do have a choice, but those sound correct, right?
Yes, ma'am.
Okay.
But other than I filed on myself because I've been in my daughter the whole life.
Okay,
and I don't want to go into. I'm sorry, sir.
The same thing I told her. Listen to the question, answer the question, and stop.
Yes, sir. Yes, sir. Apologize, sir.
The state will expand. Don't worry. Thank you.
Yes, sir. No problem.
And if Tyhisha has your address,
Yes.
would you feel in danger?
No, no, no.
And are you willing to communicate with AppClose?
Yes, I don't mind. Yes, that's not a problem.
Are you okay with Bell County and contiguous counties being a geographic restriction for your child's primary residence?
Yes, no problem.
And did you sign off on that acknowledgement of paternity when Azari was born?
Oh, yes. Yes, ma'am. Yes.
And we tried to calculate how much you would have to pay for your child, for your health insurance, but it was more than what Miss Bryant pays, correct?
Yes, yes,
Do you have any other children besides Azaria?
yes. My son, he's 22. Um, he's 22. It's just me and him here. I just bought a house 2 years ago, so it's just me and him.
Okay.
And
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 you
my
sent
daughter.
me the Cash
Oh,
App
go ahead.
receipts, and that's how we
Yes,
got the retroactive total, correct?
yes, yes. That and it's we were together when I was doing stuff, so I just gave you those receipts. I didn't know to keep receipts. Um, that's why I didn't know. I would have kept receipts. I've been there the whole time. That's why I applied for them myself.
Okay,
And she, go ahead. I'm sorry.
that's all right. Now, as far as the visits go, how many visits have you made with Azaria?
I haven't, but last week when I seen her, she let me see her. She unblocked me and allowed me to come see her. I barely even. I just dropped the stuff off on the porch when I come. I can't never. When I go over there, I always being watched by her mom and stuff. I can't never. I don't know. I shouldn't even expand on it. You're right. Maybe like about in the last month, just one time when I just went over there last week.
How often have
And,
you tried to go over there?
oh, I try to go over there like at least twice a week, once a week. But I never get in. I knock on the door, be standing outside. And I got a big house, 5 bedroom. My daughter got her own room here. That's why I found on myself. And it kind of hurt me because she said I wasn't there and I've been there. But I don't know to keep receipts when I'm for my daughter. So I'm
Okay,
not
so
on drugs. I
okay,
could
okay,
take
so
drug
good.
tests if they go ahead. I'm sorry, sir.
All right, yeah, don't jump the subject. Don't worry, we're gonna get
All
ready
right,
to
all
get
right. I'm kind of happy though, man, because I ain't been seeing my daughter. My
okay.
bad.
All right, all right. I don't want the state's not going to ask you any questions technically about being on any type of drug. I'll have to give. I always invoke anyone who's testifying before this court their Fifth Amendment right for them, because anything that can be said here can be used against you one way or the other, either as something you've done, or if you're not telling the court the truth, it could be perjury. So I always automatically invoke the Fifth Amendment right because you don't have a lawyer here to guide you through the minefield of what could happen. But I've already got something I'm gonna do here on this one, so you don't have to go into. You say you just told the court you do not use drugs. Is that correct, sir? And
No, no way.
you're
Yeah,
willing to pay for a drug test.
yeah. I could take a drug test.
All right, good enough, sir. Because that's what we're gonna do. We're gonna do a temporary order. We're gonna get you tested, and you come back negative. Guess what? You're gonna be on the fast track to seeing your daughter under what the law requires me to do, sir, ma'am, sir. And I'll let mom know that too. But you may proceed. This is going to be a temp anyway. All right.
Mr. Noel, do you have anything that you think the judge needs to know about any of this?
No, no, I'm good. No, I can't wait to see my daughter. Start seeing my daughter.
All right, I'll pass the witness, Your Honor.
All right, folks. Again, I'm looking at making this a temporary order. I got 4 levels that I usually use for break-in visits, and the first one of the 4 is with mom being present. But it sounds like y'all may have done that, but it's usually for about it's a 4 hour, not a 45-minute thing. So, and if mom's going to be present, that's fine. She can use a designated agent. She can use her mom if she wants to, but only one of them. They can't both be there ganging up on you, sir. And it's got to be for at least 4 hours. I'm going to appoint, but right now, I'm going to appoint Mr. Kurt Glass as an amicus for the court. If I need to turn him into an attorney ad litem, I will. But what amicus does, he's a lawyer who's going to facilitate what I need to get done here as far as that drug testing is going to be done. And since the only one that's alleged to be been on drugs is the dad, I'm only going to have him tested. And Mr. Glass is going to set that up with any drug test or any test now out of Harker Heights, sir. And but right now, I'm going to do both. I'm going to do a urinalysis and a hair follicle. The urinalysis would only catch cocaine or that type of drug use. Very recently, the hair analysis will catch it as odor. If either come back positive or both come back positive, then obviously I got to deal with it. But if they both come back negative, we're going to go straight into finalized order. If the urinalysis comes back negative, the hair comes back positive, I'm already going to set this out set up as temporary package. and come back after a couple of months and see if the concentration has gone down. And if it's going down, that shows that you haven't been using it since then, and we'll get you into a package where you're going to be able to work your way up to the standard of getting your daughter under a standard possession order. Like I said, the first four levels are the first 4 hours with mom. Then after that 4 hours, you get to pick the child up, sir, by yourself and go off and come back. Then after that, sir, it's 8 hours for visits, and it's usually 3 to 6. Everybody's local, so there'll be 6. After you get it for 4 hours, then you get it for 8 hours. Then you get overnight, and then you do the standard visitation. And at 4 years old, like I said, it's usually 6 visits, but since this child is older, I'm probably looking at doing it at 3 visits each. But for right now, I'm going to go ahead and look at setting y'all up as temporary joint management conservators, do the temporary order as everyone's testimony, and then have Mr. Glass set up the drug testing, sir, in Harker Heights. You're probably looking at about right at $400, sir. Can you afford that?
Ooh, I can't even afford that right now.
Here's what I'm gonna do. This is gonna be on my dime, but it's gonna be on your. If it comes back negative, sir, then I'll take care of it. If it comes back positive, you're gonna owe the people, the good folks of Bell County, $400 and some change. Understood?
All right, I get back in town tomorrow. Is that cool?
Well, okay. Well, I'm going to go ahead and have the state contact Mr. Glass, and I'm going to need both of your permission to have your contact information given to Mr. Glass. Really, technically, it's yours, sir, since he's working for me right now and not for either of y'all. So I'll need your permission to have the state give him your phone number and your email. Is that okay?
Okay, no problem. Yeah, he can call me. Yeah, we can set it up.
All right, and he's gonna set this up. And what's your work schedule, sir? Monday through Friday or what?
Yeah, Monday through Thursday.
Monday through Thursday. Okay. Well,
I took a little vacation. I'll be back tomorrow evening probably.
All right, then. Well, it'll take Mr. Glass a couple of days to get up there because he's got to send in. He's got to request me to pay the funds, so it's going to take probably sometime next week. But I'm going to go ahead and so it'll probably they're open on Saturdays, so we can do it on Saturdays. If you're off on Fridays, we can set it up on Friday.
Yeah, Saturday will be cool. I can go up there Saturday. Yeah, that'll be perfect.
But it may not be this Saturday, sir. It might not be the next Saturday. We'll wait to see if Mr. Glass can get it set up for this Saturday, and he'll contact you on that. So
okay, that's cool.
All right, I'm gonna start with you, sir. Questions?
Yeah.
What's your question? The next question, sir.
Excuse me?
You have any questions, sir?
Oh, no, I'm happy. No, I'm excited.
Right.
No, sir.
All right.
Your Honor, mom disappeared. Oh, there she might be back. There she is.
All right. In the temporary order, I'm looking at first, third, fifth Saturdays of the month. First, third, fifth Saturdays of the month from 1 o'clock in the afternoon to 5 o'clock in the afternoon for the temporary visitation package with the mom being present. And then we'll see what the drug test shows, and then I'll come up with my next order. So at this time, ma'am, do you have any questions?
Now the courtroom pivots hard. Dad denies drug use outright and volunteers testing. So the judge escalates urine and hair follicle with consequences either way. Pass clean, visitation speeds up. Fail, restrictions deepen. This isn't punishment, it's risk management when a child's safety sits center stage during custody and visitation disputes.
You muted, Ms. Bryant.
Okay.
All right, questions, ma'am?
No questions.
All right, Ms. Bryant, again, he's entitled to certain rights under the Texas Family Code, and I've got to give him those rights. But I want to find out whether or not he's on any type of drugs at this point, or if the test is positive, and then we'll figure out where we go from there. But for right now, I'm going to go ahead and appoint Mr. Glass as my lawyer, and then I'm going to, if I need to, he may end up being the ad litem for the child, which means I can transfer him over to being the child's lawyer if this thing goes sideways on us. So, because he's already going to be up to speed on what the circumstances are. But for right now, he's just going to set the drug test, get that back to me, and we'll see whether or not I need to upgrade him from a amicus to an attorney ad litem represent the child once we get the drug testing back. So, yes, ma'am.
Can the addresses be disclosed, Your Honor?
Well, for right now, the only information needs to be from Dad, and he's given us that information. Ma'am, here's the deal. If I got to make him the attorney for the child, And I'm telling you to remain neutral. Right now, he's neutral. The only thing he's got to do is set up the father's drug test, and I could have him do that as the child's lawyer too. You have any problem with the state giving the attorney your phone number and your email just in case?
No.
All right, thanks. And again, the temporary visitation is the first, third, and fifth Saturdays of the month from 1 p.m. on Saturday to 5 p.m. on Saturday. All right. So it's not 45 minutes, it's a whole 4 hours. And again, sir, how you say your son is an adult?
He 22.
All right. You can bring him with you, sir, if you want to. Ma'am, you can have someone else present with you if you want to, but nobody interfere with him actually being with the child during that time frame. Understood?
Thank you. Yeah.
Understood.
Okay.
Are we ordering temporary support, Your Honor?
Oh yeah, we already everything else is a temp. Everything that you just went over, yeah, of course.
But are we going to reserve the retroactive total, Your Honor, for
You can do
later?
that down too. The only thing I'm going to reserve is the visitation. Everything else is going to be final.
Yes, Your Honor.
All right, so that's again legal mumbo jumbo. Everything else that y'all just testified to, the child support, the retro, the repayment, all that going forward, after 30 days, that becomes final and cannot be undone. But the only thing I'll hold in advance is dealing with the visitation package that the father will get until we get the drug testing results, sorry. All right, folks, I'm gonna go ahead and let the state prepare that order, get it to both of y'all. And again, Mr. Glass will be in contact with you, definitely, sir, and ma'am, maybe even with you, okay? And if he calls me and says he prefer to be the ad litem to the child, which means he's the child's lawyer, I will go ahead and make him that. But again, remember, if that's the case, he's her lawyer, not yours, ma'am, not his. He only does what's in his client's best interest. He becomes that, and he'll complete his investigation, and he'll make recommendations and advocate for those recommendations as a lawyer. All right. All right. You understood, Mr. Noel?
No, I'm good. Thank you.
All right. All right. Again, folks, that's the first, third, and fifth Saturdays. What are we on this weekend? I think this may be the fourth Saturday coming up this weekend. It's the third.
But when my first visit.
That's what I'm looking at, sir, right now. And of course, the Microsoft calendar don't want to work on that screen, so let's see if it works on this one. There we go.
I'm excited.
This coming Saturday is the fourth Saturday of the month, sir. Yeah, we're already past the third one. So your next visitation will be the okay, I'll tell you what I'm going to do, sir. Well, just in case it's drug test weekend or whatever, okay, the first visitation you'll have will be October the 4th from 1 o'clock to 5 o'clock at the mom's residence. All right.
Okay, no problem.
And then the next one after that will be the 18th. And then again, the 1st of November. And then there are actually 5 Saturdays in November. So you get that fifth one. Question, sir.
Okay, no, I just want to say when I'm over there, a crowd of people be over there. I just want to have time with my daughter.
His bill, man.
You know, mom's
Stop. I said one person each. That's part of the court order. Violation of a court order means I can put you in Bell County for 180. All right. So people follow my orders. So, sir, you can bring your son. That's the only one I want you to bring with you. Don't bring anybody else. Okay.
I'm gonna come by myself. Yeah.
You can come by yourself or you can bring your son with you. Ma'am, you can have one person there with you, but nobody else. Understood?
Understood.
Okay. I didn't think that was going to be a problem. Okay. So this is his time and not their time. Thank you. All right, guys. Let's go ahead and I'm anticipating that we can get this one taken care of relatively fast because once the drug testing are done, it takes an hour. I mean, they're from Parker Heights in 3 to 5 days. So, Ms. Walker, said you have a date next month where Mr. Glass is going to be here. That's not the live enforcement dockets.
He will be here later in October 28th.
All right, that's fine.
Other than that, he will be on in-person dockets.
All right, October 28th will be fine. If he wants to remove him ahead of that, he can. But that'll give him a month to do what they need to do, and that'll definitely give Dad at least a couple of visits, and I'll see whether or not we're gonna move him up to the next level based on the circumstances. No drugs in the system, then ma'am, he's probably gonna move to the next level real fast, which means he gets to pick the child up for 4 hours and then bring her back.
Okay.
All right. All right, everybody, let's get this one set up and get it done. All right,
If
thank
you,
you. Anything else, Ms. Metzler?
no, I was just going to ask the parties to go back to the breakout room so I can finish the order.
All right, folks,
Okay.
let's go back to breakout and we'll take and let y'all take it from there, okay?
Okay.
See everybody
Thank you,
on
Your Honor.
October 28th, and I wish you all a
Thank
happy
you.
Halloween then, okay? Thank you.
Thank you.
Thank you.
All right. All right, we're off the record.
So say he's asking for a final order. Essentially, Your Honor, say he's asking the court to finalize the temporary order almost as is. Say understands Ms. Bryant would like some changes to the visitation due to some recent charges. She would say have been brought against Mr. Noel. But she and I do agree as to all the money parts. Your Honor, current child support, cash medical, retroactive support, cash dental. State is also asking the court, according to Mr. Glass, he has not taken the drug test. So he asked the court to order him to repay the amount that it costs for the drug test, $189 on or before a date certain. As for the rest of the court costs, Your Honor, it was already been waived, or it was already waived in the temporary order.
All right, and go ahead and make that repayment enforceable as child support. You gotta do that. Mr. Glass will give you that information. In other words, if he doesn't pay it, then we can file a motion to hold him in contempt based on not payment of that amount. So you may proceed then, Mr. Wells. Thank you.
Yes, Your Honor. As a brief background, the temporary order that's currently in place, besides appointing Mr. Glass as amicus to handle the drug testing, it appointed the two parties as joint managed conservators of the child. Child's name is Azaria Noel. With Miss Bryant having the right to establish where the child lives in Bell or any contiguous county. Communications through app close. Health insurance is through mom, a private, her employment at $104 per month. And there's a cash medical of that same amount as well. Beginning first day of October 2025. And then dental insurance is through Miss Bryant as well at $4 per month. And there's also cash dental support of that same amount beginning first day of October 2025. That's Your Honor, it does appear that the cash medical support provision doesn't put a beginning date on it. Although I think it was meant to be October 1st since the cash dental was. So I would ask the court to clarify that is October 1st.
Okay. So let's not mess this up. Go ahead and put that down as October 1st, just like the other. And the final order, it still needs to be October 1st. Maybe less enforceable for that 1st of October one, but that's the official start date. You may proceed.
Yes, Your Honor. And then the retroactive child support is, well, actually, I'll start with current child support. Current child support is $621 each month beginning October 1st, 2025. Retroactive child support was July 1st, 2023 to September 22nd, 2025. That's the day before.
That's already in the temporary order, correct?
Yeah, I'm just listing what's in the temporary order, Your Honor.
Here's the procedural split. Money becomes final. Child support, medical, dental, and retroactive totals lock in and can't be undone. Visitation stays temporary, pending drug results. That distinction is huge. Payments are enforceable now, while access remains conditional until the court gets clearer answers about parental rights, timelines, and consequences ahead.
Okay.
Yeah, that was in the amount of $12,492 as of September 22nd. And he was repaying that at $112 per month starting October 1st, 2025. So all those provisions, Your Honor, all those support provisions, I believe the state and Ms. Bryant are in agreement with. As for the other provisions, Your Honor, I ask confirm them as is, but I'll defer to you if you want any changes. The visitation section, Your Honor, in the temporary order is it's a modified step-up provision. The 1 to 5 supervised for 3 periods, then the 1 to 5 unsupervised 3 periods, 8 a.m. to 5, 3 periods, then the 6 p.m. Saturday to 6 p.m. Sunday, 3 periods. Like I said, Your Honor, State understands Ms. Bryant would like to just keep the supervised part, keep that indefinite, not indefinite, until further order of the court, due to some charges that she would say have taken place recently. State will defer to you on that.
Okay.
And that's it.
All right, I may have Mr. Glass confirm those charges, but the fact that the gentleman did take the drug testing is a red flag to the court. So I will be, I'll look at going ahead and doing that once I hear the testimony of the mother and she can confirm and go give the information where these charges are pending, what they are, and I'll look at having the amicus confirm those and making this and then. Probably going ahead and just keeping the visitation as per the restricted branch of the visitation package that we did, because again, he hasn't completed the drug test and he's got other matters that even though he hadn't been convicted, there are the charges, and that plus the not taking the drug test, yeah, that would give the court cause for concern that I would want to keep the visitation restricted. So at this time, Ms. Bryant, raise your right hand. All right, ma'am, you solemnly swear or affirm any testimony you're going to give here today is the truth, the whole truth, and nothing but the truth. So help you, ma'am.
I do.
All right, if you're officially under oath, I'm going to go ahead and let the state call you as a witness. The amicus may have a couple of questions for you, but probably not a lot. But I'll go ahead and let Mr. Welch pull through this one up, and then let the ad litem, the amicus, ask you questions as necessary. You may proceed at this time, Mr. Welch. Thank you.
Thank you, Your Honor. State calls Tisha Nicole Bryant. What is your full name?
Tahisha Nicole Bryant.
What is the full name of the child in this case?
Azaria Leanne Noel.
When was Azaria born?
She was born May 29th, 25.
So how old is she?
She's 4.
All right. I'm going to be going through the temporary order, ma'am. If you don't agree with something, just say you don't.
Okay.
So, do you agree for, as in the temporary order, for you and Mr. Noel to be continue to be appointed joint management conservators of Azaria?
No.
All right. So, what charges are you saying there that that dad has been recently faced?
He was, I wrote it down. He was charged with aggressive assault with bodily injury.
And who is the alleged victim?
And he was also put on,
Wait, ma'am,
it's his son.
Ma'am, stop. One question at a time, ma'am. The question, the charge is what the state's asking about first. Thank you. Don't go. So you may proceed, Mr. Wells.
Thank you, Your Honor. So, ma'am, yeah, just focusing for, and you'll have time at the end, ma'am, if you want to say something that I've missed out. Who is the alleged victim for this aggravated assault?
His son.
And just to be clear, this son is not in this case. It's a different child.
Yes.
All right. Is the child him, or is the son an adult?
His son is an adult.
Okay. May proceed, Mr. Wells.
All right. And so, do you know if Mr. Noel if there's any like orders or something preventing him access to any children? Like a restraining order?
Yes, there is a restraining order that was put in place between him and his son.
Is this the reason why you do not want to continue to be joint managed conservators?
Yes.
Are you still fine with having the right to status where the child in this case lives, but with a restriction to Bell or any county that's borders Bell?
For right now, yes.
Do you agree to actually strike that, Your Honor? What health insurance is the child currently on right now?
I have Cigna with Scott and White.
And is this the health insurance that's referenced in the temporary order that costs you $104 per month?
Yes.
Do you agree with the court continuing the cash medical support of $104 each month, beginning October 1st, 2025?
Yes.
And what about dental insurance? Does the child have that?
Yes.
Is that also the dental insurance referenced in the temporary order that costs you $4 per month through your employment?
Yes.
Do you agree to Mr. Noel paying cash dental support of $4 each month beginning October 1st, 2025?
Yes.
Do you agree to Mr. Noel to pay current child support of $621 each month beginning first day of October 2025?
Yes.
Do you agree with the court confirming in the final order the retroactive support total of $12,492.00 as of September 22nd, 2025?
Yes.
Do you agree with the court continuing the repayment on that of $112 each month beginning October 1st, 2025?
Yes. Yes.
Got it, ma'am. Do you know what non-disclosure is?
Yes. So that means it's where I'm sorry, I'm just trying to think
Your
over
Honor,
here.
may I briefly explain for her?
Yeah, go ahead, please. Get that on the record. Thank you.
So, ma'am, in a typical order, things like your address, phone number, maybe even employer, would be in it because that's what the law provides. But the court can, in its discretion, essentially redact that information, except for your email. That will always remain in there. In the temporary order, there was no non-disclosure ordered, but circumstances may have changed. Are you still fine with your information being in there, or would you like the court to
Uh,
redact it?
I would like the court to redact it.
And
The non-disclosure.
All right. And ma'am, what's the reason for that?
I'm sorry, I'm just trying to choose my words as I know what you said before about he say. With the behaviors that I have seen in the past and with what's going on this weekend, I just feel that for my safety and for my family that it would be better for my information to not be accessible.
Okay, here's the deal, ma'am. All parents have a right to know where their children are and living, so forth and so on. And again, that's kind of cryptic. And again, you said this may be based on a lot of hearsay, or at least on hearsay evidence. Again, I can only take testimony in what you're an eyewitness to. The pending charges against him, it's an adult son, so it's not going to fall under that injury to a child circumstance. Even though it is his child, he's over the age of 18. And he hasn't been convicted of it. He's only been charged. So I'm going to need something a little stronger, ma'am, to change what we have in this temporary order already. And you said incidents that happened this weekend. If you're talking about the incident that happened with this adult child, then again,
That's just one incident. I have
okay.
called the cops on him from my house I have kicked him out of my house several times with the attempt of calling the police in order to get him to leave my premises.
Okay.
And what I mean about this weekend is that this weekend, that was just like a really big escalation.
And ma'am, I'm not sure what
So
you mean. So,
what I mean is he, and this is not hearsay, he has come to my house to where he has been inside the house where his whole behavior changes, where he starts yelling, he starts cussing, he just gets outraged, and I've had to ask him to leave several times. He's popped up at my door when he hasn't been invited and caused scenes where I've had to threaten to call the cops in order for him to leave. The behavior that he has displayed in front of my child is not a behavior that a person should be acting in front of a kid, anyone's child.
okay. Did you ever call the police on him on any of these incidents, ma'am?
Yes, I have called the police on him once.
All right. Do you have a copy of
And
the
after,
you have a copy of the incident report, ma'am?
I do not have a copy of the report. I called on him from the Parker Heights Police Department when I moved out to Killeen, since I had already called the cops on him once. When I After that, me just saying that I'm going to call, he leaves because he knows that I will call. So I've never had to call before, but it still hasn't stopped him from escalating to the point to where I've had to threaten to call.
All right. Thank you. You may proceed, Mr. Welch.
Yes, Your Honor. So are you asking the court to change the visitation that's currently in place to be where he is it's supervised until further order of the court?
Yes,
Would beginning at 1 p.m. ending at 5 p.m. on the first, third, and fifth Saturdays of each month, is that something you'd be fine with?
I'm fine with that.
And what county do you live in?
I live in Bell County.
What county does he live in?
I believe it's Bell County as well. He lives in Killeen.
Do you have a particular place that you would like the supervised visitation to take place?
I don't have a place.
Tension spikes again when mom alleges recent criminal charges and escalating behavior. The judge demands verification, not fear, but acknowledges safety concerns. Non-disclosure and restricted visitation come into play while facts get confirmed. This phase shows how courts balance parental rights against unresolved risk signals involving young children and families.
That's a witness.
All right. You are the amicus, correct, Mr. Glass?
I was to assist, yes, Your Honor, specifically to assist with Mr. Noel getting a drug test.
All right, then. Do you have any questions based on what you're assigned to do on this case, sir? Do you have any questions for the witness?
Two quick ones, Your Honor. Good afternoon, ma'am. Have you ever known Larry Noel to use drugs?
I've never seen him use drugs, but I have had him say to me that he has used drugs before.
And do you know anything about his whereabouts on or about September 29th, maybe the beginning of October?
No, I don't.
All right, thank you. Pass the witness.
All right, then, Mr. Welch, any other questions of this witness?
No, Your Honor.
All right, then. Ma'am, do you know where the criminal charges are pending? What county? What city?
Killeen.
All right, so was he actually arrested?
Yes,
All right, is he still in jail or he's out on bail?
he's still in jail.
All right, then. Well, we can confirm that real quick then. Belinda, Mr. Glass, go ahead. Yeah, he's not showing up in jail. Mr. Glass is shaking his head.
He's not in jail.
No, sir, since we started. Now, Ms. Bryant did state we were talking with her, Mr. Welch and I were talking with her earlier. She did say that he got rearrested for violating protective order. He could be in booking or something like that, but I don't see any record of him being in jail right now.
Okay. All right. All right. Then anything showing that he was actually charged with something previously in the?
That's going to take probably a couple weeks to a month or so, Your Honor, to hit Odyssey.
All right. Good enough then. All right then, Mr. Welch. Any other questions?
No, Your Honor.
All right then. Anything else you want to add this time, Mr. Glass?
No, Your Honor.
All right, Ms. Bryant. Anything else you want to add, ma'am?
No.
All right, ma'am. I don't think I can get away from naming him as the joint manager conservator at this point. I will go ahead and order everything that is per the temporary order, but I will go ahead at this time and order that the court finds that the prior order visitation package, based on the most recent circumstances. I'm sorry. I'm gonna need Mr. Glass. I'm gonna need confirmation he was actually arrested on something. Okay, otherwise I can't get there. So I tell you what, ma'am, I'm going to go ahead and I'm going to have Mr. Glass see if he can find out the arrest information, so forth and so, and get that to the court. And like I said, I'm going to keep everything as per the temporary order, but I will change. I don't think I can change from joint managed conservators, but I will go ahead and change the visitation package if I can confirm that he has criminal charges pending based on assault on a family member, and we'll take it from there. But for right now, before I can go that far out, ma'am, I'll go ahead. I need to get that confirmation. And if I do, then I'll go ahead and just allow you to do the visitation back, our restricted visitation, or your child support, or the cash medical, or the dental as per the temporary order. And but I'm going to keep y'all as joint managed conservators, because I definitely don't have enough data to keep to take him down to possessory and name you sold. Is there anything? I'm gonna go hold off on making a ruling on this. I'm gonna reset this matter for our general docket. Let's see, next week is a live docket on Wednesday, so that means Tuesday is the only general docket I have next week. Mr. Glass, are you on that? Are you going to be on the general docket? I know you're probably going to be here on Wednesday with the enforcement docket.
That'd be November
Should be the 5th. Okay.
4th, I'll be there, Your Honor, and 5th, I'll be there. It's going to be a great week.
Okay, so you're there the 4th, so I'll go ahead and keep it on Zoom, and I'm going to reset this matter till after the 9 o'clock. After the 9 o'clock. Well, I almost said roll call. This is not the military docket call, and then I'll be able. And then if you can verify the information. Ma'am, you can show up on that docket if you wish. You don't have to. I'm gonna go ahead and confirm that. And if we get the arrest information confirmed, then I'll go ahead and see about changing the visitation around. If we need to reset it to another day to get that information confirmed, I'll do that. But for right now, I want to go ahead and try to finalize this matter and get the information that that I think the court will need just to change the visitation around, but not change the custody around. So at this time, Ms. Bryant, you have questions?
No.
All right, then, Mr. Glass, like I said, I'll see you after the docket call on the 4th, and I'll make a final ruling on all other aspects of this. But until then, Mr. Welch, everything else is per the temporary order. I'm looking at changing the visitation. I'm going to keep the parties as joint managing. Mom was okay with the geo restriction, so I'm going to keep that in there. And ma'am, if you want to show up on that date, and you've got some alternative spots for visitation that you might want to go with instead of your residence, then you can come in and give the court that information. But otherwise, it's going to the norm is obviously he needs to come and visit. Even the restricted visits need to have a spot, and obviously the most convenient spot is people's residence. But with circumstances like yours, that may not be possible. But if you want to show up and give the court some additional data on that, then I can look at changing that around as necessary. But at this time, like I said, I'm going to reset this matter to the 4th at 9. After the 9 o'clock docket, and hopefully I'll take that one up right away after the docket and get a ruling on this final aspect of this matter. Is there anything else you need a ruling on at this time, Mr. Welch?
So, just so that I understand, you're refading the case to November 4th, at, is there a general docket day? Are
Yes,
you
sir.
doing it at a specific time, Your Honor?
9 o'clock. I'm not going to do a special setting. I'm just going to keep it on the general docket, the 9 o'clock docket.
And it's just to have Mr. Glass confirm if he was arrested or not.
Find that information, and that way, if he can, I'll look at changing. I'll still definitely look at changing the visitation around, but I really want to see that before. And even with that, I don't think I can get to the point of changing the conservatorship around. But I will look at changing the visitation package, so he will have to remain at restricted until further order.
And you'll make your rulings well, so I guess that day would basically be a ruling only hearing, other than Mr. Glass giving the
The only thing
information.
I'm going to be ruling on is the visitation package. As per the order, sir. Yes, sir.
Oh, all right, Your Honor. So, so you're confirming the cash dental, the current child support, the retroactive support, as per the order, and then for the cash medical, Your Honor, we're adding October 1st since the order apparently.
Right. Go ahead and put that in there. It starts October 1st. The only thing that, well, now, and of course, he has until the 31st to play at 12 midnight, but the court would not more than likely find him in contempt based on that not being correct in the original order. We'll have to wait till the November items, and then going forward after that before the contempt can probably set in. But the start date should be in there, sir.
Yes, Your Honor. And then we're keeping the app close and the app close and the joint managed conservatorship with the restriction to Bell or any contiguous county.
Yes, sir.
All right. And then, Your Honor, the drug testing costs, the 189, I believe.
Yes,
that
sir. Mr. Glass is going to send you how to put that in the order, a judgment against that, and that judgment, because this is for the purposes of the child. This could be enforced as child support, which means if there ever was a motion for enforcement, that could be included in the contempt, and the court gets finding in contempt for that also.
Yes, Your Honor. And besides that, other court costs are waived.
Military service. Was it waived in the original order?
It was waived in the original order, Your Honor.
Okay, yeah. If it was waived, then the temporary order is still good. Yes, sir.
And then, Your Honor, for non-disclosure, are you denying or granting Ms. Bryant's request?
Based on the information, I'll tell you what, I'll rule on that also, but right now it's not looking ma'am, he knows where you live now, and again, he has a right to know where you're moving to. So where his child is, but if I find out Mr. Glass is able to find that, or that, and Mr. Glass check for a full criminal background on this gentleman. So if there's anything else that you can bring to the court's attention, especially convictions, then I'll make that part of the ruling also on whether or not going forward I'll grant non-disclosure.
Yes, Your Honor.
I'm looking at child support and non-disclosure. I mean, I'm looking at changing the visitation around and the non-disclosure. That's it. Thank you.
Okay.
I think that's about it for me, Your Honor.
All right, then. All right, ma'am. Again, Ms. Bryant, you don't have to be there on Tuesday morning, but we will be. And like I said, the court will take up those two items and make the court's ruling. Do you have any other questions, ma'am?
Just one. So on Tuesday, when you make your ruling, if I'm not there, how do I find out what the ruling it was?
You'll get a copy of the paperwork, ma'am, because it's going to be in the order. Or you can call the amicus, Mr. Glass can tell you. And in fact, I'll tell you what. Does Mr. Glass? Do you have her email address? You probably
I don't believe I do, Your Honor. I can give her that.
Because you're not in that line, you and me. Because before you leave, you can go ahead, if she wants to give it to you, give you her email address, and you can email her the ruling. Okay.
Yes, sir.
All right. So, ma'am, before you leave, I'll have you and Mr. Glass placed back in the breakout room, or the state. The state has your email address. Is that correct, Mr. Welch?
I do. I don't know if it's current, Your Honor, but I'll talk with her after her
All right,
hearing.
and confirm that she can give that to Mr. Glass, and he can email her on that one. Anything else, ma'am?
No, that's all.
All right, thank you very much. And Mr. Welch, anything else?
No, Your Honor. When you get your rulings on November 4th, that's when I'll draft the order and send it to everyone, I think.
All right, and I'm
Okay.
going to make my notes and say, and I'll see you on that Tuesday, Mr. Glass, and hopefully we can bring this one to a successful conclusion. Thank you very much, and we're off the record. All right, we're back on the record on Bell County College number 25 DFAM 352470. In the interest of Noel Manor Child, Larry Noel is the non-custodial party. Custodial party is Taisha Bryant, and the court had a hearing on this matter last week, and I reset it this week. I got a couple of these run together in my mind. There's this is the one, was this the one with, where one of the charges against Dad was interference with a 911 call, or is that the other case?
Judge, I think so. You may be right. This is the one where we weren't sure what Dad was charged with,
Okay.
and it looks like it's ABIFM. There may be also an interference with a 911, but I haven't been able to verify that yet.
Okay. All right. This is also failed to do his drug test, correct?
Yes, sir.
All right, then. I wrote down that I was, based on those circumstances, I was looking at just going ahead and give him some form of restricted visitation. And you're the amicus and not the ad litem, so I won't ask your information on that. But the problem was with the visitation was that I was looking at was whether or not that charge was against him, and it would be virtually impossible for me to give him any type of visitation with the mother being the custodial of the overseer of that visitation. If he's been charged with interfering with a 911 call that she tried to do to protect herself from this gentleman.
Yeah.
So at this time. Based on that information and the lack of information and the fact that he did take his drug test, I'm looking at only granting him some type of electronic visitation twice a week. I'm going to go ahead and order that the mom set up app close and all visitation, FaceTime, electronic, whatever it is, will be through app close. And to further the court, I will grant him visitation at every Sunday at 6 p.m. and every Wednesday at 6 p.m. And that he has to let mom know via app close on the Friday before for the Sunday and the Tuesday before for the Wednesday if he's going to go ahead and do that visitation. Otherwise, she didn't have to be hanging around waiting for him to show up. And based on the information we have at this time and his failure to do the drug test, and the court has no other choice than not to put mom in any type of harm's way. And based on the fact that the 911 thing was against mom, it was the information. So I'm going to go ahead and just grant him the electronic business until further order of the court. I don't like going this extreme, but again, without that data at this time, the court I feel like I have no other choice. So, and everything else is per the request of the state, child support, everything else, but that's the visitation. And until Dad, completes drug testing and there's no chance that there's any type of family violence against the mother, that's what the court's going to rule as far as this matter is concerned. You need anything else on this one, Ms. Bexler?
Your Honor, what do you want for the length of the electronic? Do you want that in the order?
30 minutes. From 6:30 to 7.
6:30 to 7 on Sunday and Wednesday?
Yes,
Okay.
this is a 4-year-old child now, so
Yeah.
Yeah. It's those 2-year-olds that that some days they can do 2 hours and some days they'll do 2 minutes. It's just left up to them. It's their world and we live in it.
And write it down, Your Honor. And then I don't know that I got a ruling on any court costs, I feel like.
He's responsible for court costs. He has until November 30th of 2026 to pay the court costs of the bill.
Let's make sure, Your Honor, that there was nothing else. I believe that the Communication fee act clause was already ruled on in temporary order.
Yeah.
And in the temporary order, there was no, the addresses were disclosed, Your Honor. Do you want to continue doing that?
Going forward, non-disclosure is granted.
Okay.
Again, I'm worried about what happens if for any criminal matter. So
No finding of family violence, Your Honor.
I'm sorry. Oh yeah,
No finding.
I'm finding the family violence. She testified to that's what he did. So I'm gonna make a family violence finding. Yes. Yeah. Yeah, he had been, I only need preponderance of the evidence. I don't need beyond a reasonable doubt. So to do that.
Okay, Your Honor, I believe I got it then.
Let me write that down. I'm on docket 2. Transfer to 911 the call. Okay, and call.
Final ruling hits hard. No drug test, family violence findings, and no in-person visits. Dad gets only electronic contact twice weekly, tightly scheduled. Support orders stand firm. This case proves compliance matters. Like, comment, and subscribe for more real courtroom outcomes and legal reality checks you can learn from every hearing.